Should the information of public sector be available to everyone? How should such a flow of information be regulated? Why would the accessibility of information ever be so controversial? Hello everyone, this is Pranav Bhardwaj and welcome you all to yet another daily legal updates from the law offices of Vivek Tanwar. On this episode of the Law Years, we shall cover the basics of Right to Information Act of 2005 as widely as possible, what all challenges do people face, and intricacies involved in the law. This last fact is especially important as the world today continues to grapple with the COVID-19 pandemic. Our topic today is Right to Information, also known as the RTI, the movement defined in the early 2000s to ensure the free access to and information from a public authority. Talking about the right to information, the right to information gained power when Universal Declaration of Human Rights was adopted in 1948, which provided everyone the right to seek, receive information and ideas through any media and regardless of frontiers. Further, it was the International Covenant on Civil and Political Rights 1966, which under Article 19 stated that everyone shall have the right to freedom of expression, the freedom to seek and impart information and ideas of all kinds. The genesis of Rti Law can be traced back to 1986, whereby the Supreme Court in the case of L.K. Kolwal versus State of Rajasthan had directed the freedom of speech and expression provided under Article 19 of the Constitution of India. It further went on to state that Article 19 clearly implies right to information as a part and parcel of right to freedom of speech and expression, as without information, the freedom of speech and expression cannot be fully used by the citizens. It is crucial to note that Right to Information Act was tabled on December 23, 2004 by the then UPA government. Consequently, the Right to Information Bill was passed by the Parliament of India on 15 June 2005 and came into force with effect from 12 October 2005. In the coming years, it has been regarded as the revolutionary act which tend to provide access and open various governmental institutions by expanding democratic space and empowering the ordinary citizen to exercise far greater control over the state power, thus keeping a check over the corruption and arbitrariness in various public institutions. It won't be wrong to state that introducing the right to information has been regarded as the paradigm shift from the state-centric to the citizen-centric model of development in India. The evolution of the law can even further be traced back to 1990s when Mazdoor Kisan Shakti Sangathan began a historic 40-day-long dharna, sit-in protest to demand the right to information in the city of Biawar, which is located near Ajmer in Rajasthan. The novelty of this protest was the demand for information by poor instead of expected basic needs like food and shelter. During the protest, a memorandum was given to the sub-divisional officer at Biawar that demanded local expenditure records. In the same timeline, certain colonial laws were also put into question. These colonial acts were said to prevent the access to information and thus was said to be violative of fundamental right to seek information. Under the RTI Act, it is imperative that the public authority must provide and ensure the free access to and information from the public authority by replying expeditiously and within a period of 30 days. In cases where the matter involves the petitioner's life and liberty, the same information has to be provided within a period of 48 hours. The Act also requires every public authority to computerize their records for wide dissemination and to proactively publish certain categories of information so that the citizens formally can access and have to take the minimum recourse to request for the said information. While enacting the said RTI Act, the main objectives of the legislature were primarily to empower the citizens, to promote the transparency and accountability, to contain corruption, and finally was to enhance the people's participation in the democratic process. Now let's have a look at the features of the Act. Until 24th August 2020, the Right to Information Act used to extend to the whole of India except the state of Jammu and Kashmir. But consequent to the passing of the Jammu and Kashmir Reorganization Act of 2019, the Jammu and Kashmir Right to Information Act of 2009 and the rules thereunder were repealed, and the Right to Information Act of 2005 along with its supplemented rules thereunder were enforced from 31st October 2019. Talking about as to what do we mean by information. The term information has been defined under Section 2F of the Right to Information Act of 2005 as any material in any form including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. It is crucial to note that the said information can also be accessed in the electronic form as well. Talking about the definition of right to information, the right to information has been defined under Section 2J of the Act of 2005, and it means that the right to information accessible under this Act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents, records, taking notes, extracts or certified copies, taking certified samples of materials, or obtaining information in any form of diskettes, floppies, or any other electronic mode, or through printouts. One of the most crucial questions which arises is related to the public authority, as to what all are included in the public authority. Public authority tends to include any authority or any body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament or the state legislature, or by notification issued or order made by the appropriate government, yet another feature of the Act has been mentioned under Section 4 of the Right to Information Act, which requires suo motu disclosure of information by each public authority. However, such disclosures have remained less than satisfactory. Now coming to what all information has been exempted from being furnished under RTI Act. All such information has been mentioned under section 8, which goes on to mention the information which is being exempted. The Act also provides for appointment of the information commissioners at the central and the state level. Public authorities have designated some of its officers as Public Information Officer. They are responsible to give information to a person who seeks information under the Act. Usually, in normal course, information to an applicant is to be supplied within 30 days from the receipt of application by the public authority. If the information sought concerns the life or liberty of a person, it shall be supplied within 48 hours. In case the application is sent to the Assistant Public Information Officer or it is sent to a wrong public authority, 5 days shall be added to the period of 30 days or 48 hours as the case may be. Apart from all these features, it is important to note that there was no that the RTI Act of 2005 did not create any new form of bureaucracy for implementing this particular law. Instead, it tasked and mandated the officials in every office to change their attitude and duty from one of secrecy to one of sharing and openness. It carefully and deliberately empowered the Information Commission to be the highest authority in the country with the mandate to any officer in the country to provide information as per the provisions of the Act. And it further empowered the Commission to fine any official who did not follow the mandate. Right to information has been seen as the key to strengthening participatory democracy and ushering in people-centered governance. It won't be wrong to say that access to information can empower the poor and weaker sections of the society to demand and get information about the public policies and action thereby leading to their welfare. It showed an early promise by exposing wrongdoings at high places, such as an organization of Commonwealth Games and allocation of 2G spectrum and coal blocks. Right to information opens up government records to public scrutiny, thereby arming citizens with a vital tool to information, inform them about what the government does and how effectively are they doing their work, thus making the government even more accountable than ever before. Further, the RTI also improves decision making by public authority by removing the unnecessary secrecy. However, there are many challenges to the said Act and there are many hurdles when it comes to the implementation of the said Act. There have been different types of information which has been sought by the public, which usually appears to be not of any public interest and sometimes can be misused to harass the public authorities. That is it for today's podcast. We all really hope that you really liked it. We'll be back tomorrow with yet another episode. To make sure you don't miss it, be sure to subscribe to us over the Spotify and Instagram. To learn more about our research team and other teams, you can visit us at advocatetanwar.com. You can also find us on other social media platforms such as Facebook and Instagram. Thank you for listening. See you next time.